Chair Shields, members of the committee, for the record, my name is Jim Guse, G-U-S-E. I'm an attorney in private practice in Portland. I'm at the firm of Ball Janik. For the last 10 years, I have represented homeowners associations, individuals, businesses in insurance coverage disputes. And this is both on first-party claims and third-party claims. I've seen firsthand how insurance company practices impact Oregon, especially Oregon businesses, and small businesses are hit the most. Let me just give you a couple of real-world examples. In the first-party context, currently, for instance, I have a client who owns a small commercial building. The tenant vacated prematurely and the building was vandalized. A claim was made to the insurance company. More than a year has passed and the claim has not been adjusted. My client doesn't have the money to fix the building. It doesn't have rental income. And it's running out of money to pay its lawyer to fight with its insurance company. And after a year, its decision now as to whether it settles for pennies on the dollar because it simply can't afford to fight anymore. One of the tactics used in this case and in many others is to request information and document after document after document. And what I've seen is they wait until you find a document or piece of information that you don't have. Perhaps the record was destroyed. Perhaps you don't have it anymore. And then the tables are turned on you because you can't provide them the information, and they claim that you're the one holding up the claim. In the third-party context, similar things happen. Small businesses get sued. They tender to the insurance company. The insurance company either doesn't respond at all or denies coverage summarily. They have a choice now whether to hire a lawyer to defend them in the lawsuit and a lawyer to fight with their insurance company. And you have to remember these are unforeseen contingencies which most small businesses aren't prepared to handle. Most small businesses can't afford to hire one lawyer, nonetheless two lawyers to fight with both the person suing them and the insurance company. These are insurance companies who have built their entire fortune based on slogans like, "You're in good hands," okay, "We're on your side." But when it's time to pay the claim and to protect these businesses, they're not there. I would like to address the notion that I have heard in some of the previous testimony that somehow this bill, particularly 686, is anti-business. In my opinion, in my experience, that couldn't be further from the truth. And I think when we look at this, it's important to take a step back. There is a statute on the books which requires insurers to treat people fairly. ORS 746-230 is already there. And so when an insurance company complains that it's going to cost more if 686 goes into law, they're already required to comply with this statute. Insurance companies who are going to have an economic loss are those that aren't treating their customers fairly. And I would wager to say that if their costs are currently low, they're artificially low. The reason that their costs are low is because their current practices that we're talking about are preventing legitimate claims from being made. Claims that should be paid out, folks don't have the wherewithal or the money or the time to pursue those. And so Oregon consumers, especially small businesses, are already paying because of the insurance practices. It is also, I think, important to point out that what insurance companies are saying is that costs will increase to everybody if they're forced to treat customers fairly. In essence, they're asking that the cost of their bad behavior be spread among everyone. There's a real easy solution to that. Insurers don't have to engage in the kind of practices that are prohibited here. And if they don't engage in those practices, then the cost simply won't go up. At the end of the day, nobody is asking to impose special restrictions on insurance companies. They simply need to be treated like all of the other Oregon businesses that are already subject to the Unlawful Trade Practices Act. And all of the other Oregon businesses that are required to comply with this statute, it's not been my experience that the cost of buying a car or buying cable television or any of the other hundreds of businesses in Oregon that are required to follow this statute, our costs didn't go up then. This is not an anti-business bill. This is a lifeline for scores of businesses whose doors are going to shutter if they continue to be treated this way by insurance companies. Thank you.
Thank you. Any questions? Senator Marsanderson.
Mr. Chair,
How many states, or let's just put it this way, the surrounding states like Washington or California, Idaho, are they, is insurance not under the Unlawful Trade Practices Act?
Insurance, I know I'm most familiar with Washington. In Washington, sorry, Senator Montes Anderson. In Washington, there's the Insure Fair Conduct Act, IFCA, which provides a private enforcement mechanism for the types of conducts that we're talking about here. So there are statutes in place that do protect insurance companies, protect insureds against these types of practices. And it's been my experience, because we represent clients in both Washington and Oregon, that claims are treated much more expediently. Insureds are given an explanation as to why their coverage has been denied, benefits that their neighbors right across the border don't get. I, in fact, have advised contractors, as Mr. Weil was talking about, that they'd be better off moving to Washington, because their insurance is so important to them, especially with contractors who get sued frequently. They would be better off, their bottom line, and to the success of their company, if they moved. So other states do protect their consumers, and especially small businesses, and simply we don't have that here.
Senator, I can give you the number of states. There are 35 states out of the 50 do not exclude the insurance industry from legislation like this. In the West, these states do not exclude the insurance companies. Arizona, Texas, Utah, Wyoming, Washington, New Mexico, Nevada, and California.
Chair Shields, Senator Anderson, and even Utah, which is one of the states that doesn't exclude, has a very much more robust set of statutes to protect the small business and consumer with respect to insurance claims. Our practice is Oregon, Washington, Idaho, Utah, and Arizona. And in every one of those states, other than Oregon, the opportunity for the consumer of the insurance product to have tools to force the insurance companies to abide by the terms of their contracts are much more robust than they are here in Oregon. So bringing this back under the UTPA is just one step, but it's a very important step to help all of us understand here that we are looking at the insurance company's obligations in the same way. And by the way, I've not heard any of the contractors or clients that we represent complain that their rates are higher than what folks are experiencing here in Oregon. I just don't think that's a valid argument.
Senator Brzezinski.
I'm sorry, the gentleman that just spoke. You gave testimony saying that you were here and that we should have received some testimony from another gentleman.
Leland Jaquay.
Did that come in electronically, or is it hard copy?
I thought it came in hard copy, and I'll certainly check.
I was looking electronically. I didn't see it.
Yeah, Chair Shields, Senator Brzezinski, I'll check to make sure that gets in your hands.
There's some stack here. It may be here. I just wanted to make sure it is part of the record. So
certainly. Thank you very much.
Mr. Guse, how would you categorize Ball Janik? Is it a plaintiff's firm, business firm?
Well, I'm in the construction defect group, and so that is primarily plaintiff related. I've been there a year. The 9 years prior to that, I represented directly contractors, business owners, and individuals. So I've been on every side of this, and it's the same issue wherever you go. Every case, I've been in hundreds of cases where this act would have a significant and direct impact on the outcome of that lawsuit or coverage dispute. So sitting on both sides of the table, it hasn't mattered to the impact that I think this statute would have.
Okay, thank you. Thank you very much, panel.